What's up, smarty people? It's KeysDAN, RadioWhat.com, DJLittleRock.com, KeysDAN Show with some news. Trump too small. Supreme Court says jab at Trump can't be trademarked. This is according to USA Today. In Washington, the Supreme Court on Thursday unanimously rejected the attempt to trademark the lewd phrase, Trump too small, a decision that recognized the government's long history of setting boundaries on trademarks. We see no reason to disturb this long-standing tradition, which supports the restriction of the use of another's name in a trademark, Justice Clarence Thomas wrote. The government's trademark office, which denied the application, had pointed to a law that bars trademarks involving a person's name without written consent. But a federal law appeals court backed the applicant, California attorney Steve Elster, holding that the law would restrict his freedom of speech and criticism of a public official. Elster wanted to sell T-shirts with the phrase he says conveys the idea that former President Donald Trump's features and his policies are diminutive. The crude joke harkens back to a personal jab against Trump during the 2016 campaign from Senator Marco Rubio, Republican of Florida, then a Republican presidential rival. Rubio said Trump had disappropriately small hands. And you know what they say about men with small hands, Rubio said, taking a beat before adding, you can't trust them. Defending himself, Trump said he's aware of the belief that the size of a man's hands is related to another part of his anatomy. I guarantee you there's no problem on that front, he said, without getting into the suggestive meaning of the description. During their October oral arguments, the justices observed there have long been restrictions on trademarks. Those restrictions don't prevent the use of the phrase, they noted, even if it can't be trademarked, to significantly limit the ability of competitors to market products with the same words. But the court said in its opinion, there's no First Amendment right to piggyback off of someone else's name. The Biden administration backed the trademark office's decision protecting Trump from the insulting trademark. Trump was not a party in the case. Vidal versus Elster. Let's bring a little laughter to the dry world of trademark law. Roy Gutterman, director of the Tully Center for Free Speech at Syracuse University, said the case offered some levity into the dry world of trademark law and rollicking political discourse. After diving into centuries of intellectual property law, the court said there can be prohibitions on the use of names without violating the First Amendment. When the case began, Gutterman brought a Trump too small T-shirt and hung it in his office. I suppose under today's decision, he said, I can now go ahead and make my own without violating Mr. Elster's intellectual property rights. Well, there's some news. For more, stick around. This is the KeysDAN Show. It's KeysDAN, RadioWhat.com, DJLittleRock.com. Peace. I'm out of here.